Welcome to this comprehensive masterclass on the Insolvency and Bankruptcy Code 2016. In this session, we will explore one of the most important topics for CIA final law, the Corporate Insolvency Resolution Process, commonly known as CIRP. We will understand the complete journey of insolvency resolution, beginning with the appointment of the interim resolution professional, moving through claim verification and constitution of the Committee of Creditors, and finally examining the role of the resolution professional and the functioning of the COC. Instead of studying individual provisions in isolation, we will connect every step logically so that the entire process becomes easy to understand, remember, and reproduce in the examination. Before diving into specific sections, let's first understand the overall framework of CIRP. Once insolvency proceedings commence, the law immediately focuses on stabilizing the affairs of the corporate debtor. An interim resolution professional is appointed to take control of the management and operations. Claims are then collected and verified, after which the Committee of Creditors is constituted. The COC subsequently decides whether the IRP should continue as the resolution professional or whether another professional should be appointed. Throughout the process, strict timelines and procedural requirements are maintained because the primary objective of the Insolvency and Bankruptcy Code is not merely recovery of debt, but timely resolution and preservation of enterprise value. Let's begin with Section 16, which deals with the appointment of the Interim Resolution Professional, or IRP. The Adjudicating Authority appoints the IRP on the insolvency commencement date itself. If the insolvency application is filed by a financial creditor or the corporate debtor, the proposed professional is appointed, provided no disciplinary proceedings are pending. In the case of an operational creditor, if no name is proposed, the Adjudicating Authority seeks a recommendation from the IBBI, which must suggest a suitable professional within 10 days. The IRP continues in office until a resolution professional is appointed under Section 22. When the interim resolution professional takes charge, their first responsibility is to understand the true financial condition of the corporate debtor. This involves collecting information about assets, finances, and business operations. The IRP also receives and verifies claims submitted by creditors and uses those verified claims to constitute the Committee of Creditors. Until a resolution professional is appointed, the IRP monitors the company's operations, safeguards its assets, and ensures that the insolvency process moves forward in an organized and transparent manner. One of the most significant effects of CIRP is the transfer of management control. From the date of appointment, the affairs of the corporate debtor vest entirely in the IRP. The powers of the board of directors or partners stand suspended, and all key decisions are taken by the IRP. Company officers must report directly to the IRP, while banks and financial institutions are required to follow the IRP's instructions. This shift ensures transparency and prevents existing management from interfering with the resolution process. The objective of CIRP is not to shut down a business, but to preserve its value. Therefore, the IRP must manage the corporate debtor as a going concern. To achieve this, the IRP may appoint professionals, such as accountants or legal advisors, modify existing contracts, and even enter into new agreements if required. The IRP can also raise interim finance to support business operations. A special exam point to remember is that creditor consent is not required when the value of the encumbered property is at least twice the amount of the debt. Once the public announcement is made, creditors must submit proof of their claims using the prescribed forms. Financial creditors submit claims through Form C, operational creditors use Form B, and workmen or employees submit claims through Form D. These standardized forms help the IRP process claims efficiently and ensure that every category of creditor is properly represented during the insolvency resolution process. Timelines are extremely important under the Insolvency and Bankruptcy Code. Creditors must normally submit claims by the date specified in the public announcement. The IRP then has 7 days to verify those claims. Within 2 days after verification, a report certifying the constitution of the Committee of Creditors must be filed with the Adjudicating Authority. Even if a creditor misses the original deadline, the law permits claim submission up to 90 days from the insolvency commencement date, ensuring that genuine claims are not excluded. After the Committee of Creditors is formed, its first meeting must be held within 7 days. During this meeting, the financial creditors decide whether the existing IRP should continue as the resolution professional or be replaced. This decision requires approval by at least 66% of the voting share. If a replacement is proposed, the Adjudicating Authority seeks confirmation from the IBBI. Until such confirmation is received, the existing IRP continues to function, ensuring there is no disruption in the resolution process. Once appointed, the resolution professional takes responsibility for conducting the entire CIRP. The RP protects the assets of the corporate debtor, manages business operations, maintains the claims list, and convenes meetings of the Committee of Creditors. The RP also prepares the information memorandum, invites prospective resolution applicants, and presents their plans before the COC. In addition, the RP represents the corporate debtor in legal proceedings and pursues avoidance transactions wherever necessary. The law requires the resolution professional to be completely independent of the corporate debtor. The professional must not be a related party and should be eligible to serve as an independent director under the Companies Act. They should also not have recent associations with the company's auditors or consulting firms, having significant dealings with the corporate debtor. These conditions ensure impartiality and maintain trust in the insolvency resolution process. The fees payable to the resolution professional, along with the expenses incurred in keeping the business operational, form part of the insolvency resolution process costs. These costs enjoy priority over payments to all other creditors. The Committee of Creditors can also replace the RP at any time during CIRP by passing a resolution with 66% voting share. However, if disciplinary proceedings are pending against the proposed replacement, the existing RP continues until a suitable replacement is confirmed. The information memorandum serves as the foundation for preparing a resolution plan. It contains critical information regarding the corporate debtor's financial position, assets, liabilities, disputes, and business operations. To protect sensitive information, access is granted only after resolution applicants provide a confidentiality undertaking. They must comply with confidentiality laws, protect intellectual property, and avoid unauthorized sharing of information. This ensures transparency while safeguarding the interests of the corporate debtor. After claims are verified, the interim resolution professional constitutes the Committee of Creditors under Section 21. The COC generally comprises all financial creditors of the corporate debtor. If no financial creditors exist, the Code provides an alternative mechanism for constitution. An important concept for exams is that if a person has both financial and operational debt, voting rights are available only for the financial debt portion. Similarly, assignment of debt does not change its original nature. To ensure fair decision-making, related party financial creditors are generally excluded from participation and voting in COC meetings. This prevents conflicts of interest and protects the integrity of the resolution process. However, an important exception applies to regulated financial creditors who became related parties solely due to debt-to-equity conversion before insolvency commencement. In consortium lending arrangements, each creditor receives voting rights based on the amount of financial debt owed specifically to them. When a financial debt is owed to a large class of creditors, individual participation in COC meetings becomes difficult. To address this challenge, the law provides for an authorized representative. The IRP offers 3 insolvency professionals for selection, and the creditors choose one to represent them. The authorized representative attends meetings, participates in discussions, and votes according to the voting share of each creditor, ensuring efficient and effective representation. A major amendment notified in September 2024 introduced the concept of an interim representative. Earlier, delays often arose because the appointment of an authorized representative required approval from the adjudicating authority. To avoid such delays, a temporary representative can now be appointed while the permanent application is pending. This interim representative enjoys the same rights and duties as a regular authorized representative and ensures uninterrupted representation for large groups of creditors such as homebuyers. The Committee of Creditors takes decisions through a voting mechanism based on financial debt share. Most routine decisions require approval by at least 51% of the voting share. However, major matters such as replacement of the resolution professional require a higher threshold of 66%. The COC also has the right to seek financial information from the RP whenever required, and the RP must provide the requested information within 7 days. Let's conclude with a quick recap. The IRP takes charge immediately after insolvency commencement and manages the corporate debtor until a resolution professional is appointed. Claims are verified within 7 days, while delayed claims may still be filed within 90 days. The Committee of Creditors plays a central role in decision-making, with voting rights based on financial debt share. Related party restrictions ensure fairness, and the 2024 Interim Representative Amendment strengthens representation for large creditor classes. Understanding this entire sequence as one connected process makes the Insolvency and Bankruptcy Code much easier to remember and apply. Welcome to this CA Final IBC Revision Masterclass. In this session, we will decode some of the most frequently tested provisions of the Insolvency and Bankruptcy Code, 2016. We will begin with the constitution and functioning of the Committee of Creditors, understand the role of the authorized representative, examine the critical powers that require prior approval under Section 28, and then move into the important disqualifications under Section 29A. Finally, we will understand the mandatory requirements of a resolution plan and the approval process, followed by the Committee of Creditors. Think of this as a complete roadmap that connects the entire insolvency resolution process into one logical flow. Before diving into the provisions, let's understand the journey. Every corporate insolvency resolution process revolves around 5 key pillars. First is the Committee of Creditors, which drives major decisions during insolvency. Second is the authorized representative, who acts as the voice of creditor classes. Third comes Section 28, which identifies important actions that cannot be taken without prior COC approval. Fourth is Section 29A, which filters out undesirable resolution applicants. Finally, we have the resolution plan, where compliance, feasibility, and creditor protection are examined before approval. If you master these 5 areas, you cover a significant portion of the practical framework of IBC. The constitution of the Committee of Creditors follows strict statutory timelines. Once claims are received, the interim resolution professional must verify them and then file a report certifying the constitution of the COC before the Adjudicating Authority within 2 days. After filing this report, the first COC meeting must be conducted within 7 days. These timelines are not merely procedural formalities, they ensure that the insolvency process moves quickly and efficiently. Since the COC becomes the primary decision-making body during CIRP, any delay in its formation can slow down the entire resolution process. That's why the Code imposes strict compliance requirements on the IRP right from the beginning. The composition of the Committee of Creditors depends on whether financial creditors exist. In a normal situation, all financial creditors of the corporate debtor become members of the COC, and meetings are conducted by the resolution professional. However, if the corporate debtor has no financial debt, or all financial creditors are related parties, an alternative structure applies. In such cases, the COC consists of the top 18 operational creditors by value, 1 representative of workmen, and 1 representative of employees. This ensures that even when traditional financial creditors are absent, stakeholders with economic interest in the corporate debtor continue to participate in the insolvency resolution process. The resolution professional must ensure regular meetings of the Committee of Creditors. Generally, a meeting must be convened before 30 days pass from the previous meeting. The COC may allow a longer gap, but at least 1 meeting must occur every quarter. The Code also empowers creditors holding at least 33% voting share to demand a meeting, and the RP is obligated to convene it. Similarly, if creditors representing 33% voting rights propose an agenda item, that proposal must be included for discussion. These provisions ensure that important decisions are not delayed, and that significant creditors have a meaningful voice in the insolvency process. For a COC meeting to be valid, notice and quorum requirements must be satisfied. Normally, every participant must receive at least 5 days written notice. The COC may reduce this period to 24 hours, but if an authorized representative is involved, the notice cannot be reduced below 48 hours. Regarding quorum, members representing at least 33% of voting rights must be present, either physically or through electronic means. If quorum is not met, the meeting automatically stands adjourned to the same time and place on the next day. Interestingly, the adjourned meeting becomes valid regardless of the number of members attending. Not everyone attending a COC meeting has voting power. Voting rights belong primarily to financial creditors and authorized representatives. Certain other stakeholders, such as members of the suspended board, partners, and operational creditors, whose dues constitute at least 10% of total debt, may attend meetings but cannot vote. In specific situations, the COC may also invite the RA competent authority or providers of interim finance as non-voting observers. An important examination point is that the absence of these non-voting attendees does not invalidate the proceedings of the meeting. Attendance rights and voting rights are therefore 2 completely different concepts under the IBC framework. Voting share determines the influence of a creditor in COC decisions. For financial creditors, voting share is calculated by comparing the debt owed to a particular creditor with the total financial debt of the corporate debtor. Where the COC consists only of operational creditors, voting rights are based on the proportion of debt due to each creditor compared with total debt, including workmen and employee dues. After discussions conclude, the resolution professional conducts voting through electronic means and records, whether members voted in favor, against, or abstained. Understanding voting share is crucial because almost every important COC decision is based on these percentages rather than the number of creditors present. The authorized representative acts as a bridge between large classes of financial creditors and the committee of creditors. The AR participates in votes according to instructions received from represented creditors, whether physically or electronically. At the same time, the AR owes a fiduciary duty to act in the interest of those creditors. Another important responsibility is communication. The AR must circulate agendas, minutes, and important information to represented creditors, and also file voting instructions with the COC to ensure proper recording by the resolution professional. In simple terms, the AR converts hundreds of individual creditor voices into an organized and legally recognized voting mechanism. The voting method of an authorized representative depends on the nature of representation. When representing multiple individual financial creditors, the AR must vote separately for each creditor exactly according to the instructions received. If a creditor provides no instruction, the AR must abstain on that creditor's behalf. However, where the AR represents a class of creditors under Section 21(6), a different rule applies. The AR casts a unified vote based on the decision supported by more than 50% of the voting share of those creditors who actually voted. This majority decision becomes binding for the entire class. One important exception is Section 12A withdrawal applications, where this unified voting rule does not apply. Section 28 is one of the most important provisions for examinations because it restricts the powers of the resolution professional. Certain major actions cannot be taken unless prior approval of the committee of creditors is obtained through a 66% voting share. These include raising excess interim finance, creating security interests, changing capital structure, recording ownership changes, undertaking related party transactions, amending constitutional documents, delegating authority, changing management, and altering auditor appointments. The key point to remember is the consequence. Any action taken without the required 66% approval is void. In other words, Section 28 acts as a powerful control mechanism over the resolution professional. Section 29A prevents undesirable persons from taking control of a distressed company through the resolution process. A person is ineligible if they are an undischarged insolvent, a willful defaulter, or connected with a non-performing asset account that remained classified as an NPA for at least 1 year before CIRP commencement. However, important exceptions exist. Eligibility may be restored if overdue amounts are cleared before submission of the resolution plan. Certain financial entities that are not related parties also receive exemptions. Additionally, where an NPA was acquired under a previously approved resolution plan, a special 3-year relaxation may apply. These safeguards ensure that defaulting persons do not easily regain control of distressed assets. Apart from financial defaults, Section 29A also targets legal and regulatory misconduct. A person becomes ineligible if convicted for serious offenses carrying imprisonment of 2 years or more under specified laws or 7 years or more under other laws. Eligibility is generally restored after 2 years from release. A person is also disqualified if barred from acting as a director under the Companies Act 2013 or prohibited by SEBI from trading in securities or accessing capital markets. The underlying principle is simple. Individuals facing serious legal or regulatory sanctions should not be entrusted with the responsibility of reviving an insolvent corporate debtor. Section 29A extends beyond the applicant and examines past conduct and relationships. Ineligibility arises where the applicant was involved in preferential, undervalued, extortionate, or fraudulent transactions for which the adjudicating authority has passed an order. Similarly, a person who gave a guarantee for a corporate debtor and failed to honor it after invocation becomes ineligible. Another important concept is that of connected persons. Even if the applicant personally satisfies all eligibility conditions, disqualification may still arise if a promoter, management person, holding company, subsidiary, associate company, or related connected person falls within the prohibited categories. The provision even extends to equivalent disabilities under foreign laws. Before presenting a resolution plan to the committee of creditors, the resolution professional must verify strict compliance requirements under Section 32. First, CIRP costs must be paid in priority to all other debts. Second, operational creditors must receive at least the minimum amount prescribed under the code. Third, dissenting financial creditors must receive not less than the amount they would obtain in liquidation. The plan must also provide for post-approval management, implementation mechanisms, supervision arrangements, and complete legal compliance. Think of these conditions as mandatory checkpoints. If any one of them is missing, the plan cannot move forward for approval. The final stage is approval by the Committee of Creditors. Once the resolution professional confirms compliance, the plan is presented to the COC for evaluation. The committee examines feasibility, viability, and fairness of distribution among stakeholders. Approval requires not less than 66% voting share of financial creditors. At this stage, eligibility under Section 29A is checked once again because an ineligible applicant cannot be approved under any circumstances. If the plan fails to secure the required majority, the COC may seek fresh resolution plans, or, where resolution becomes impossible, the corporate debtor may ultimately move toward liquidation. This is the decisive stage where the future of the corporate debtor is determined. Welcome to this CA Final IBC revision session, where we move from resolution planning to liquidation. In this chapter, we will understand how resolution plans are evaluated, voted upon, and approved under the Insolvency and Bankruptcy Code 2016. We will also examine the role of the Adjudicating Authority, landmark Supreme Court judgments, immunity provisions under Section 32A, and the circumstances in which liquidation becomes inevitable. Think of this session as the final phase of the insolvency journey, from selecting a resolution plan to understanding what happens when resolution succeeds and what happens when it fails. By the end, you'll have a complete picture of the transition from CIRP to liquidation. One of the most fundamental principles of the Insolvency and Bankruptcy Code is that liquidation is always the last resort. Whenever a corporate debtor defaults, the law first attempts revival through the Corporate Insolvency Resolution Process, commonly known as CIRP. The objective is to preserve value, protect stakeholders, and keep the business alive wherever possible. Only when all reasonable attempts at resolution fail does the code permit liquidation under Chapter 3. Therefore, there is absolutely no concept of direct liquidation under the IBC. For examination purposes, remember this simple sequence: first resolution, then liquidation. Liquidation is not the starting point. It is the fallback option when revival is no longer possible. When a resolution plan is being considered, the resolution applicant is allowed to attend the Committee of Creditors meeting where that specific plan is discussed. This attendance helps the applicant explain the proposal and address any concerns raised by creditors. However, attendance does not automatically mean decision-making power. The resolution applicant has no voting rights in the COC meeting unless the applicant independently qualifies as a financial creditor of the corporate debtor. This distinction is important because the ultimate decision remains with the creditors, whose money is at stake. Therefore, the applicant may present and clarify, but the power to approve or reject the plan remains firmly with the Committee of Creditors. Regulation 39(3)(b) prescribes a structured process for evaluating resolution plans. First, every submitted plan must be examined according to a predetermined evaluation matrix, ensuring fairness and consistency. Next, the Committee of Creditors must record detailed deliberations regarding the feasibility and viability of each proposal. Feasibility refers to whether the plan can realistically be implemented, while viability focuses on whether the business can survive in the long term. Finally, all eligible plans must be put to vote simultaneously. This simultaneous voting mechanism prevents bias and allows creditors to compare competing plans on equal footing. The regulation therefore promotes transparency, efficiency, and objective decision-making throughout the evaluation process. The method of approval depends on the number of plans under consideration. If only one resolution plan is presented, it is approved if it secures the required voting majority. When multiple plans are voted upon simultaneously, the plan receiving the highest votes, provided it meets the requisite majority threshold, is treated as approved. In cases where two or more plans receive equal votes and satisfy the minimum requirement, the Committee of Creditors must apply a pre-announced tiebreaker formula to select the successful plan. If none of the plans receive sufficient votes, creditors conduct another round of voting on the plan that received the highest support earlier, subject to overall CIRP timelines. Once the Committee of Creditors approves a resolution plan, the resolution professional submits it to the Adjudicating Authority under Section 31. The Adjudicating Authority then examines whether the plan satisfies all mandatory requirements specified under Section 32. If satisfied, it passes an order approving the resolution plan. If the plan fails to comply with statutory requirements, the authority may reject it. Approval by the adjudicating authority is a critical milestone because it converts the creditor's commercial decision into a legally binding arrangement. Any challenge to such approval can only be made on the limited grounds specifically provided under Section 61(3), ensuring certainty and finality in the insolvency process. Once approved by the adjudicating authority, the resolution plan becomes binding on a wide range of stakeholders. This includes the corporate debtor, employees, members, creditors, guarantors, and all other parties connected with the resolution process. Even central government, state government, and local authorities become bound by the approved plan. Certain post-approval obligations also arise. The successful resolution applicant must obtain all required statutory approvals within 1 year or within the period prescribed under applicable laws, whichever is later. The moratorium ceases to operate, and the resolution professional must submit CIRP records to the IBBI database. An important exam point is that Competition Commission approval, where required, must be obtained before Coca Provo. 2 landmark Supreme Court judgments have shaped modern insolvency jurisprudence. The first is the Essar Steel case, which introduced the famous fresh slate doctrine. According to this principle, once a resolution plan is approved, liabilities not included in that plan stand extinguished, allowing the successful applicant to take over the business free from past burdens. The second is the case Sashidhar judgment, which reinforced the supremacy of the Committee of Creditors' commercial wisdom. The court clarified that neither the resolution professional, NCLT, nor NCLAT can interfere with commercial decisions taken by the COC. Together, these judgments strengthen creditor autonomy and provide certainty to successful resolution applicants. Section 32A provides an important protection mechanism for successful resolution. Once the adjudicating authority approves a resolution plan, the corporate debtor's liability for offenses committed before the commencement of CIRP comes to an end. The corporate debtor cannot be prosecuted for such offenses, and even pending prosecutions stand discharged from the approval date. In addition, the property of the corporate debtor receives protection against actions relating to pre-CIRP offenses, subject to statutory conditions. The purpose of this provision is straightforward. If a new management takes over a distressed company, it should not be burdened by the misconduct of previous management. This encourages genuine investors to participate confidently in the resolution process. The immunity granted under Section 32A is not automatic. It becomes available only when control of the corporate debtor passes to a genuinely new and independent management. The new controller must not be a promoter, a person previously involved in management, a related party, or someone suspected of abetting the offense. Equally important is the carve-out provision. While the corporate debtor may receive immunity, individuals responsible for wrongdoing do not escape liability. Designated partners, officers in default, and persons directly or indirectly involved in the offense continue to face prosecution. Therefore, Section 32A protects the company and its revival, but it does not provide a safe haven to those who actually committed the misconduct. Appeals against approval of a resolution plan are allowed only on specific grounds under Section 61(3). These include contravention of law, material irregularity by the resolution professional, inadequate provision for operational creditors, failure to prioritize CIRP costs, or noncompliance with IBBI requirements. Alongside appeals, the Code also monitors delays through Regulation 40A and 40B. The resolution professional must file Form CIRP 7 whenever key activities such as public announcement, appointment of RP, issuance of information memorandum, release of RFRP, or completion of CIRP are delayed. This filing must occur within 3 days of the due date and continue every 30 days until completion, ensuring regulatory oversight throughout the process. Section 33 identifies 5 situations in which liquidation becomes mandatory. First, when no resolution plan is received within the prescribed CIRP period. Second, when the adjudicating authority rejects a submitted plan. Third, when the Committee of Creditors fails to approve a plan within the permitted timeline. Fourth, when the COC itself decides to liquidate the corporate debtor through a vote of at least 66% voting share. Finally, liquidation may occur if an approved resolution plan is later contravened and the adjudicating authority confirms the breach. These provisions ensure that an unsuccessful resolution process does not continue indefinitely and that stakeholders receive a clear legal outcome. Once any liquidation trigger arises under Section 33, the adjudicating authority is required to take specific statutory actions. First, it must formally pass the liquidation order. Second, It must issue a public announcement informing all stakeholders that the corporate debtor has entered liquidation. Third, it must send a copy of the order to the authority where the corporate debtor is registered, such as the Registrar of Companies. These duties are mandatory rather than discretionary. The objective is to ensure transparency, notify stakeholders, and initiate the formal liquidation framework under the code. For exam purposes, remember this simple sequence: liquidation order, public announcement, and notification to the registration authority. A liquidation order produces several immediate legal consequences. No suit or legal proceeding can be initiated by or against the corporate debtor. However, the liquidator may institute proceedings with prior approval of the adjudicating authority, and certain notified transactions remain outside this restriction. Another important effect is that all assets in liquidation proceeds vest in the liquidation estate. Additionally, the liquidation order operates as a deemed notice of discharge for officers, employees, and workmen. An important exception exists where the business continues as a going concern during liquidation. In such cases, the discharge provision does not apply, allowing business operations to continue under the liquidator's supervision. The Sreedhar Tripathy case is a powerful illustration of the commercial wisdom doctrine. In this case, the corporate debtor had remained non-functional for 19 years. Its machinery had become scrap, and revival prospects were practically non-existent. Recognizing this reality, the Committee of Creditors chose liquidation instead of spending additional resources on a futile resolution process. The decision was challenged, but both NCLT and NCLAT upheld it. The tribunals emphasized that the COC is empowered to decide liquidation at any time after its constitution and before confirmation of a resolution plan. The judgment reinforces the principle that genuine commercial decisions of creditors are generally beyond judicial interference. Let's conclude with the key examination takeaways. First, CIRP must always precede liquidation. Direct liquidation is not permitted. Second, the commercial wisdom of the Committee of Creditors remains supreme and is generally non-justiciable. Third, approved resolution plans provide a fresh slate by extinguishing liabilities not included in the plan. Fourth, Section 32A grants immunity to the corporate debtor for pre-CIRP offenses, but not to individuals responsible for wrongdoing. Finally, remember the crucial 66% voting threshold for COC decisions relating to liquidation. If these principles are clear in your mind, you will be able to answer most conceptual and practical questions relating to resolution plans and liquidation under the Insolvency and Bankruptcy Code.